The war on our Second Amendment rights is heating up like never before. From federal overreach on bumpstocks and pistol braces to unconstitutional power grabs at the state and local levels, it's clear that anti-gun politicians and bureaucrats are playing the long game. But here's the thing, they keep losing, and it's thanks to patriots who refuse to let their freedoms be trampled. In this video, we'll cover the biggest battles happening right now: Memphis's illegal gun bans that blatantly violate state law, the fight against ATF overreach on force reset triggers, and the latest court cases on assault weapon bans and bumpstocks. With 26 states standing shoulder to shoulder to push back against federal infringements, the Pro-2A movement is stronger than ever. We'll unpack the wins, the ongoing fights, and the strategies to stop anti-gun zealots in their tracks. By the end of this video, you'll have the updates you need to stay informed, energized, and ready to defend your freedoms. This isn't just about the Second Amendment, it's about the future of liberty in America. The fight is on, and we're in it to win it. Let's get right into it, starting with Memphis. In a bold move that has ignited a fervent defense of Second Amendment rights, the Memphis City Council recently passed ordinances aiming to ban constitutional carry, restrict assault weapons, and implement red flag laws within city limits. These were primarily driven by a surge in local violent crime, including a record 398 homicides in 2022. While these measures were not directly a response to the March 2023 Covenant School shooting in Nashville, that tragic event intensified statewide discussions on gun control. The Nashville shooting, where 6 individuals lost their lives, highlighted vulnerabilities in existing firearm regulations and spurred debates on enhancing public safety. Consequently, the Memphis City Council's actions reflect a broader concern over gun violence in Tennessee, influenced by both local crime rates and high-profile incidents like the Nashville school shooting. These actions stand in direct opposition to Tennessee's robust preemption laws, which unequivocally prohibit local governments from enacting firearm regulations more stringent than state statutes. Tennessee's preemption statute asserts that the state legislature preempts the whole field of the regulation of firearms, leaving no room for municipal deviations. The council's decision has not gone unchallenged. Gun Owners of America, in collaboration with the Tennessee Firearms Association, swiftly filed a lawsuit against the city of Memphis, asserting that the newly adopted ordinances flagrantly violate state law. GOA's Senior Vice President, Eric Pratt, emphasized the gravity of the situation, stating, "Tennessee has one of the strongest preemption laws in the nation, and the very reason it exists is to prevent radical anti-gun cities from enacting the very sort of draconian policies Memphis just adopted." The legal action reveals something. Municipalities attempting to circumvent state authority on firearm regulations will face formidable challenges. Tennessee's preemption laws are designed to maintain uniformity in gun regulations across the state, preventing a patchwork of local ordinances that infringe upon citizens' rights. The lawsuit seeks an immediate and permanent injunction to halt the enforcement of Memphis's ordinances, reinforcing the principle that local governments cannot override state law. The swift legal response and the strong likelihood of the ordinances being struck down highlight the effectiveness of state-level protections in safeguarding constitutional rights. The Memphis case exemplifies the vigilance and readiness of Second Amendment advocates to challenge overreach and defend the freedoms enshrined in the Constitution. As the legal battle unfolds, it sets a precedent for addressing attempts by local governments to impose restrictive gun laws in defiance of state statutes. The outcome of this case will likely deter other municipalities from pursuing similar paths, knowing that such actions will be met with immediate and robust opposition. While Memphis's overreach has been met with decisive action, the fight to protect Second Amendment rights continues on multiple fronts. In the legislative arena, Senate Democrats have recently intensified efforts to regulate firearm accessories, signaling ongoing challenges and the need for continued vigilance. Their attempts to undermine our Second Amendment rights never stop, and this time they're trying to push a legislative ban on bumpstocks. After the Supreme Court's landmark decision in Garland v. Cargill, which struck down the ATF's unconstitutional bumpstock ban, you'd think they'd get the memo. But no, these geniuses decided to double down. Instead of respecting the highest court in the land, they've dragged the issue back into Congress, hoping to score points with their anti-gun base. Let's be real, this isn't about public safety or preventing crime. It's about control. The ATF's administrative ban was slapped down because it blatantly exceeded the agency's authority, and the Supreme Court rightly reminded everyone that such sweeping policy changes must come from Congress, not unelected bureaucrats. But even with this clear directive, the Democrats are still playing political games, pushing legislation they know doesn't stand a chance. Here's why it's doomed. Republicans now control both the Senate and the House. This attempt to push a legislative ban on bumpstocks is dead on arrival, yet the Democrats persist. Not because they believe they'll win, but because they need to keep up appearances for their anti-gun supporters. It's pandering, plain and simple. They want to look like they're doing something about guns, even if it's all for show. This entire charade highlights just how desperate they've become. They can't stand that patriots like you are winning. They lost in court, they lost in the ATF, and now they're trying to pass legislation they know has no legs. It's almost laughable. Almost. But what's not funny is how these repeated attacks on our rights continue to waste time and resources. The Garland v. Cargill decision was a massive victory for gun owners and a reminder of the importance of checks and balances. It reinforced that agencies like the ATF don't get to rewrite laws on a whim. And it put power back where it belongs, in the hands of elected legislators. Yet here we are, watching Democrats try to override that victory with legislation they know won't pass. It's nothing more than a desperate attempt to cling to relevance in a political landscape where their anti-gun agenda is losing ground. This isn't just about bumpstocks. It's about the broader fight to defend the Second Amendment. Every time they lose, they find another way to attack. Every victory we secure, they try to undermine. But here's the good news. The fight isn't just ours. It's theirs to lose. And speaking of wins, Texas has delivered another major blow to federal overreach, this time with pistol braces. In a landmark victory for patriots, a federal judge in Texas has vacated the Bureau of Alcohol, Tobacco, Firearms, and Explosives rule, classifying pistols equipped with stabilizing braces as short-barreled rifles. This decision, delivered in June 2024, challenges the ATF's authority and underscores the judiciary's role in curbing regulatory overreach. The ATF's rule aimed to reclassify firearms with stabilizing braces, subjecting them to stringent regulations under the National Firearms Act. However, the court found that the agency overstepped its bounds, violating the Administrative Procedures Act by failing to provide a detailed justification for reversing its long-standing position on pistol braces. This ruling not only nullifies the ATF's rule, but also sets a precedent against similar regulatory actions that bypass legislative processes. For gun owners, this decision is a significant affirmation of their rights. The court's ruling protects individuals from potential criminal liability and the burdensome process of registering firearms under the reclassification. Moreover, it reinforces the principle that regulatory agencies cannot unilaterally impose restrictions without clear legislative backing, thereby safeguarding against future overreach. Currently, the case is under appeal in the Fifth Circuit Court of Appeals. Legal experts anticipate that the appellate court will uphold the district court's decision, given the strong arguments presented against the ATF's rule. Should the case advance to the Supreme Court, it could result in a definitive ruling that limits the ATF's regulatory authority, potentially reshaping the landscape of firearm regulations in the United States. This victory in Texas is a testament to the resilience of Second Amendment supporters and their commitment to challenging unconstitutional regulations. As the legal battle continues, attention now turns to Maryland, where an assault weapon ban faces scrutiny, promising further developments in the ongoing defense of gun rights. In a significant development for Second Amendment advocates, the Supreme Court is poised to review Snope versus Brown, a pivotal case challenging Maryland's assault weapon ban. This case, formerly known as Bianchi versus Brown, questions the constitutionality of prohibiting semi-automatic rifles commonly used for lawful purposes, including the popular AR-15. Maryland's 2013 Firearms Safety Act, enacted in the aftermath of the Sandy Hook Elementary School tragedy, bans the sale, transfer, and possession of certain semi-automatic firearms and magazines exceeding 10 rounds. Proponents argue that these measures are essential for public safety, while opponents contend they infringe upon constitutionally protected rights. The Fourth Circuit Court of Appeals upheld the ban, asserting that such weapons are not protected by the Second Amendment. However, the Supreme Court's 2022 decision in New York State Rifle and Pistol Association v. Bruin established a new standard for evaluating gun laws, emphasizing historical context and the text of the Second Amendment. This precedent has prompted a reevaluation of existing firearm regulations, including Maryland's ban. The Supreme Court's decision to hear Snope v. Brown could have far-reaching implications. If the court overturns Maryland's ban, it would set a precedent that may invalidate similar laws in other states, reinforcing the protection of commonly owned firearms under the Second Amendment. This outcome would be a monumental victory for gun rights advocates, affirming the right to possess firearms in common use for lawful purposes. Gun owners should closely monitor the progression of this case. The Supreme Court's current term began in October 2024, with a decision expected by June 2025. The court's ruling could redefine the legal landscape of firearm ownership in the United States, influencing future legislation and judicial decisions. In other recent legislative discussions, several anti-gun advocates have displayed a concerning lack of understanding regarding the Second Amendment and firearm regulations. Notably, Senator Mazie Hirono of Hawaii expressed astonishment over the Supreme Court's 2008 District of Columbia v. Heller decision, which affirmed an individual's right to possess firearms unconnected with service in a militia. Senator Hirono remarked that the ruling was pretty much an astounding decision to me when suddenly individuals could, under the Second Amendment, individuals could own firearms. This tone-deaf take overlooks the historical context of the Second Amendment, which has long been interpreted to protect individual gun ownership rights. Similarly, during a Senate Judiciary Committee hearing, a representative from the Giffords Law Center to Prevent Gun Violence made inaccurate claims about pistol braces. The representative asserted that stabilizing braces convert pistols into short-barreled rifles, thereby increasing their lethality and concealability. However, this perspective fails to acknowledge that stabilizing braces were originally designed to aid disabled shooters in handling firearms more effectively. Moreover, attaching a brace does not alter the firearm's fundamental characteristics or make it more concealable. Attorney Ryan Kleckner, a former Army Ranger and firearms law expert, provided compelling testimony during the same Senate hearing. He emphasized that banning items like Bumpstocks would not deter criminals already inclined to violate existing laws. Kleckner stated, "Banning an item or making it illegal is not going to prevent a criminal from using it. It's already illegal for that shooter to be a mass murderer." His insights highlight the importance of addressing the root causes of gun violence rather than imposing blanket bans on firearm accessories. Misinformation and misunderstandings among public figures can significantly influence the narrative surrounding gun control. When policymakers and advocacy groups disseminate inaccurate information, it can lead to misguided legislation that infringes upon the rights of law-abiding citizens. Therefore, it is crucial for Second Amendment supporters to remain vigilant and well-informed. By actively engaging in informed debates and challenging misconceptions, advocates can ensure that firearm regulations are based on factual evidence and respect constitutional rights. And that's all we have for you today. The fight for the Second Amendment rages on, but victories are stacking up. From Memphis's unconstitutional gun bans being challenged to the ATF's pistol brace overreach struck down in Texas, and Maryland's assault weapon ban now under Supreme Court scrutiny, the Pro-2A movement is now stronger than ever. And with Trump winning the presidency, now's a really good time to get into firearms for both defensive and recreational use. But let us know your thoughts in the comments, and don't forget to like, share, subscribe, and click the bell icon to stay informed and engaged in the fight for our rights.